Good morning to prevailing public health concerns. This is, by my count, I suppose, the fourth time we've done it this way, and by and large, our experiences has worked fairly well. Occasionally, we'll have a technical glitch. Our technical people and counsel work with those who will argue at a time, and we do the very best we can to make it work. But you never know what might occur with technology. So we've usually as we try to move forward with today's list. I conclude by reminding all of you, though, in any event, that we do have the benefit of your briefs. We're very familiar with the case. So you needn't worry if you miss a point or if there's a technical issue, because there's nothing that you would argue that would be encompassed in your written presentations. With that, we'll call the first case.
First matter is the Commonwealth of Pennsylvania versus William Henry Cosby Jr. Representing Mr. Cosby is Ms. Jennifer Bonjean. Representing the Commonwealth is Ms. Adrienne Jappy. And
the appellant was convicted of aggravated indecent assault denied. During trial, the Commonwealth introduced 5 witnesses under evidentiary rule 404B to testify regarding their accusations of sexual assault against the appellant for purposes of establishing appellant's
Mr. Cosby's first trial, but there can be no confidence that it did its job at the second, where the jury was bombarded with prior bad act evidence. Indeed, half of the prosecution witnessed 404B allegations. The allegations, the most damning ones, came from a deposition that should not have been admitted in the first instance on account of an agreement with the Montgomery County District Attorney not to prosecute Mr. Cosby, promise on which he relied to his grave detriment. As argued in our briefs, none of the prior bad act evidence served a legitimate non-propensity purpose. But that aside, consensus surely must be reached that Mr. Cosby suffered unquantifiable prejudice where the CEA evidence or the prior bad act evidence his second trial, converting it from a trial on a single offense to a trial of his character. With that, I would entertain any questions from the board.
Counsel, this is Counsel Justice Doherty speaking. Let me just zero on the civil deposition. Even taking into consideration and finding this true that he, Mr. Cosby, your client, did not believe that he was to be prosecuted for the events involving Wisconsin State. When confronted with a question plausibly implicating criminal conduct, in any deposition, an individual has an affirmative duty to invoke their Fifth Amendment regarding other issues or potential other criminal. The fact was done by counsel Mr. Cosby or Mr. Cosby himself.
I think that speaks to the agreement, that the agreement not to prosecute was linked to the willingness to give a civil deposition, which this in part from looking at the press release, which demonstrated that not only did the district attorney at the time, Bruce Castor, decline to prosecute, but he mentions in the press release that there was going to be ongoing civil litigation. So, and you also can look at Mr. Schmidt's testimony, who testified that it was our understanding that the promise not to prosecute would be honored as Mr. Cosby agreed to sit for this deposition and give testimony and not invoke his Fifth Amendment right, which he did, again, to his detriment. And in hindsight, of course, we would have preferred to have seen a written agreement or something on the record that would have reflected that this was the arrangement that had been made. But I think the fact that Mr. Cosby actually sat, answered questions for 4 days, and I think it speaks to the first point. And this is evidence in and of itself. Relied on this representation. No one was for a deposition and not invoke their Fifth Amendment right, guilty or innocent, if there was the possibility of criminal prosecution looming over your head. So the fact that he did leads to the only reasonable inference that he believed that in order to not be prosecuted this week, this was part of the agreement that he complied with. And as a result, to the extent that the prosecution wanted to use the deposition testimony, once they decided to prosecute him, that deposition testimony should have been off the table at a minimum.
Justice Mayer, at the first trial, I don't think it's in our record, but it is properly before. Was there any prior bad act testimony?
There was one prior bad act witness who testified at the first trial, correct? That's right.
I understand your argument. I tend to agree that this evidence was extraordinarily prejudicial. But there's a trial court discretion component here. In your view, if the trial court had allowed one, would that have been an abuse of discretion? Or if the trial court allowed two? And where do we draw a line between abuse of discretion and discretionary call, which perhaps we would have not made, but not powerful. We don't have the power to overrule.
Yes, understood, Your Honor. Our position is the trial court abused its discretion for two reasons. One, because not even one prior bad act witness served, but also because the admission of 5 prior bad act witnesses was duly prejudicial to the point that no limiting instruction could have cured it, and that these discrete allegations from 15 to 22 years ago had such a value as compared to the danger of unfair prejudice that it seems clear that the court did not exercise discretion in allowing 5. So I think it's twofold. Our position is that there was no theory of admissibility that was for a non-propensity purpose. But even if this court were to disagree with that, at the end of the day, 5 witnesses, plus all of this vague testimony about quaaludes and Jane Does that were just exploited to the hilt during the closing arguments that frankly were just contorted from the deposition testimony in the first place, put Mr. Cosby in a position where he had no shot. The presumption of innocence just didn't exist for him at that point. And so I think the court abused its discretion in both of those ways.
Counsel, this is Justice. Thank you.
Good morning.
Good morning.
we're not going to have time for rebuttal.
Yes.
I would like you to, for me, spend a little bit of time talking about why the evidence was offered through these prior bad act witnesses did not go to the common plan or scheme or a signature crime, which is what I understand that your reported use was.
Yes, Your Honor.
Prior bad act witnesses did not go to establish a common plan or scheme or a signature crime, which is what I understand their reported use was.
Yes, Your Honor. So at the outset, I would say the common plan is in an apt theory of admissibility here for two reasons. One, because the prior bad act evidence was not part of a single overarching plan, which I think the prosecution concedes. It also was inapt because identity was not a disputed fact in this case. And the overwhelming authority from this Commonwealth and across the country is that signature-like prior bad acts, also known as modus operandi evidence, is relevant to prove identity. In fact, the test in this Commonwealth is that it must be so nearly identical to be the handiwork of the same perpetrator. But when identity is not in dispute, the evidence simply registers with the jury as propensity evidence. To put it very simply, where identity is a dispute, a modus operandi may be perfectly proper. Where identity is not in dispute, it just amounts to propensity evidence. And make no mistake about it, that is what the prosecution is asking this court to do, is sanction propensity evidence. And simply because the prosecution can shoehorn prior bad act evidence into some exception, it does not make it admissible, since it may not bear on a matter at issue in the case. But with that said, if any members of the court disagree with that analysis, and that may be the case, even if this court believes that the signature crime approach is the appropriate approach to this case and a proper theory of admissibility, the prosecution still does not prevail here because the prior bad acts were general in nature insofar as they involved sexual misconduct of some type and the use of an intoxicant. They were not nearly identical as to the charged offense, at least any more nearly identical than they would be to, frankly, almost the majority of acquaintance assaults or date rape situations, where we know that intoxicants almost invariably play a role in those types of assaults. But if you want to get more granular about it, in this case, we have prior allegations, again, 15, 22 years old prior allegations that involve a number of distinctions from the charged offense. I think one of the most astounding ones is the nature of the relationship. You cannot compare the relationship that Mr. Cosby allegedly had with these 5 other women that he did with the complainant. This was an 18-month relationship. This was a relationship that, at least by her own testimony, was built on friendship. They exchanged gifts. They spoke regularly. This notion that he was mentoring her, well, I mean, anybody who comes in contact with Bill Cosby is going to sort of, given who he is, could perceive that he would be a person who's wise and would be able to give you advice. But this is not the scenario where he sought her out or she sought him out for some to advance her acting career or a modeling career. This was a chance encounter. He brought her into his inner circle as a friend, introduced her to people he knew. He traveled to places with her, where New York, Connecticut. So the nature of this relationship was very different. In the 5 prior bad act cases, one woman had not even been invited to Mr. Cosby's home. She just came with a friend, and she was not an actress, and she didn't. This was just a woman that showed up to come socialize with Mr. Cosby with their friend. The other women had met him once or twice. So again, the nature of the relationship I think is a marked difference between the prior bad acts. We also have very different sexual type of contact. One of the women, Ms. Lublin, testified that she doesn't recall any sexual contact other than some bizarre behavior where he allegedly stroked her hair. And some women describe, intercourse where other women describe that there was something that didn't involve penetration. So the sexual acts themselves were very different. The nature of the intoxicant was different. In some cases, like Ms. Baker-Kinney, she said, I took the Quaalude. He offered a Quaalude to me, I took it. There's no evidence whatsoever that anybody else was given a Quaalude. Even among the other 4 prior bad act witnesses in the charged offense, for as much as Quaaludes played a role in this case from the prosecution's perspective, they will concede they have no evidence that Mr. Cosby gave Ms. Constant a Quaalude or anybody else, frankly. The only person who speaks about a Quaalude is Ms. Baker-Kinney, who said, he offered me one and I took one. So, yes.
This is Justice Todd.
Good morning.
Good morning. Let's assume we accept your argument on prior bad acts, that it was error to introduce it. Could you address the harmless error question? Could this possibly have been harmless error?
It could not have been harmless error, and I think we need only look at the first trial to get our answer to that. It is clear that the prosecution wanted and needed propensity evidence, but they had no right to it. You don't get to make up for weaknesses in your case by bombarding each jury with rank propensity evidence. That's not fair. And frankly, the prosecution's case, the evidence was ample. They didn't need this evidence. They had the complainant's testimony. They had corroboration. They even had an expert who was able to rehabilitate any cross-examination. And with that, the first jury still could not reach a unanimous verdict. And as a result, I don't think that this is a case where there was overwhelming evidence of guilt. And I think we have the benefit of this first trial to tell us that. And yet, the prejudice, again, was extraordinary in this case, and no curative instruction could have solved it. I think the Third Circuit said it best when it commented that when evidence of this magnitude is presented to a jury, it is most difficult, if not impossible, to assume the continued integrity of the presumption of innocence. And to put it, yes.
Now, so this is Justice Doherty again.
Yes.
Let me return to the civil deposition because I struggle. It appears that your argument is based upon promissory estoppel, correct?
Correct.
So again, when we're looking at the parties with regard to promissory estoppel and each individual factor, the concern that I have is here, as you indicated in your opening, they're trying to dissect or look at his entire life. And that being that, I assume you're implying that he's a celebrity, therefore, this is even a harsher look at him. With that in mind, my concern is how are we to accept one of the second prongs of promissory estoppel is justifiable reliance on the inducement when we have to look at this individual. We're dealing with an individual who's knowledgeable of the legal system. He's in entertainment. It's not as if this is his first advancement or use of lawyers. So how is it when you take into consideration the inducement, AKA the Castor press release for which he signed, indicating that Cosby would not be prosecuted for the instant matter of investigation? How is it that we're to find justifiable reliance of an individual who's intellectually, at least legally superior than the average person, based upon his history, as you brought forth in your argument, to really rationalize that he justifiably relied upon refusing the DA's refusal to prosecute, yet provided additional elements of other individuals, not the focus of the initial criminal investigation, and yet affirmatively refused to invoke a Fifth Amendment. I'm struggling with your argument.
And I understand that, Justice. I think I would disagree with one premise, which is that the assumption that, and with all due respect to Mr. Cosby, that he is particularly savvy about the law or that he has an understanding of these things. I think high-profile people often rely almost to their detriment on legal advice. They have a lot of legal issues and they defer many times to their attorneys who tell them, this is the deal. You know, this is part of the agreement. You will not be prosecuted. Go sit down, cooperate. You cannot invoke your Fifth Amendment right. And he relied on that. And I think that this court's decision in Stipetich really helps guide us here, because in that case, you had two defendants who were arrested, and even with the assistance of their counsel present, brokered a deal with a law enforcement officer who said, listen, if you tell us the source of this contraband, we won't prosecute you. And again, here are defendants, I don't know how savvy they were, but they were there with their attorney, and the attorney said, yes, go ahead and tell them that. And naturally, this court ultimately concluded that it's the district attorney's job to decide who prosecutes, not law enforcement officers. But the court still determined that that evidence should be suppressed because he relied on that. And as a matter of equitable principles and fairness, I think that we would have to assume that that for Mr. Cosby, again, I don't think he should be punished because he followed the advice, believed there was a deal, and invoked his Fifth Amendment right. Again, in hindsight, we certainly would have all done this very differently. But I think the fact that he did sit and gave the testimony, the only fair inference is that he did rely on the representations, and that it was done with the assistance of his attorney who testified. I understood through his criminal counsel, and I understood from through the criminal counsel from the district attorney that this was connected. He had to testify in order to not be prosecuted. And that's the best way he can answer that.
I'm sorry, I didn't mean to interrupt you. It's Justice Barrett. I want to follow up on Justice Doherty, and then I have an independent question. And I don't mean to nitpick, but there's nothing in my preparation that indicated that Mr. Cosby has ever indicated in his testimony or his protestations that he relied upon the alleged deal with DA Castor. In the trial court, and I noted this because, again, it's a partisan case, the trial court found Mr. Schmidt, who was Attorney Schmidt, who was attorney at that point, not credible, found that his testimony was not persuasive. I can't recall, but indicated that he negotiated a deal with the National Enquirer and this settlement and et cetera, and just didn't believe that he had done this. And again, the first question I asked you was trial court discretion. Here again, you fall under the constraint of trial court determination of credibility, which is binding on us. So doesn't that sort of get you to the wrong side of Justice Doherty's question?
Well, I think you are absolutely correct that this court owes great deference to the trial court's credibility findings. They are not, however, unassailable. And I believe that the dispositive facts in this case, the ones that are not disputed, still lead us to the conclusion that at least the deposition must be suppressed. And those are that we know that Castor chose not to prosecute. We know that. Whether that promise was intended to bind future prosecutions, I suppose, is a credibility determination that the court resolved against Mr. Castor. But we do know at that moment he declined to prosecute. He represented that in the press release, and that it was bound to or linked, there was some nexus to the civil case. And again, I can't create a formal writing that didn't exist. It just didn't exist. And again, we can look in hindsight and wish it did. I think we all do. But I think the reason it's troublesome for us is that we can't wrap our head around the fact, why would somebody sit for a deposition with prosecution looming over their head in such a serious matter? And I think while that may lead somebody to a different conclusion, for me, it leads to the conclusion that, well, clearly there must have been a understanding and a confidence that if he did so, there would not be a prosecution. And that is, I guess, the best way I can answer that question.
I think that's fair. Let me ask you one last question. I hope I'm done. You, as part of your able presentation, detailed the nature of the relationship between the defendant and the victim. And one of the exceptions in 404B is absence of mistake with specificity. Why isn't it reasonable that the evidence of the prior bad acts comes in to show that Mr. Cosby was not mistaken, that this was a consensual relationship?
Well, I would point out that using absence of mistake to show some type of mens rea, if you will, because that's what we're talking about, is unconventional, to say the least. There's a dearth of authority in this Commonwealth and elsewhere that absence of mistake is an exception that applies where the physical elements of the crime are not in dispute. You usually see it, of course, when a defendant says, well, my conduct was an accident or it was a mistake. And that's sort of the traditional scenario. Here, the prosecution is using it really for a novel idea that it allows us to look into Mr. Cosby's mind and determine whether or not whether he could have mistakenly assessed her ability to consent. And it's our position that it is highly distinguishable because unlike the defendant in Tyson, Mr. Cosby had not been accused of those prior bad acts before the incident with Ms. Constant. So one of the focuses that the court had in the Tyson case was that there the defendant had been accused, he had lodged a consent defense, he had been prosecuted, so he certainly had knowledge. He suffered the penal consequences of his behavior before, and he was on notice that when he had this similar encounter, that he should have known better. But here we have a very distinct scenario where Mr. Cosby did not face any of these accusations prior to the charged offense. That it came after the charged offense. Moreover, we don't know whether Mr. Cosby would even allege consent as to those 5 prior acts. The record is silent on that. He could say, I don't know who that woman is. I never met that woman, or we never had any sexual relationships. The record is simply silent on that. So I think to sum up on this point, using absence of mistake as an exception, or excuse me, to use prior bad act evidence to show a mens rea in this case, which is what the prosecution is trying to do, has a number of pitfalls that are identified by Professor Imwinkle Reed. It's just not
Counsel, Ms. Bongini, this is Tom Saylor. The professor concludes very tellingly that the trier of fact can reason from the starting point, the uncharged crime, to a conclusion about the mens rea of the charged crime, only through an intermediate assumption about the accused character or propensity. That's a difficulty with this approach, isn't it?
Yes, it is. And that's
ably carried. The jury is going to have to make that leap. And that's the overtly difficulty with applying this doctrine.
That's absolutely right. That the jury has to make a intermediate determination about tendency or disposition, that because he acted with an alleged mens rea in the past, he had a tendency or disposition to do so on the charged offense. So in that sense, that is why, frankly, prior bad act evidence just doesn't really work very well when looking at mens rea types of issues, as opposed to issues that involve physical acts, which are far more predictable.
Now, could I ask you if you could sum up in a word or two as we're going to move to the Commonwealth?
Yes, Your Honor. Thank you very much. I would just point out that prosecuting agencies in this Commonwealth and states across the nation have chipped away at the general prohibition on prior bad act evidence for decades. And with this case, they truly seek to obliterate it. This court should rule to protect the time-cherished rule, not just because it's Bill Cosby or to right a wrong in this case, but because the constitutional guarantees of the presumption of innocence, the burden of proof, and even due process that frame our criminal justice system are at stake. And I thank you all.
Thank you. We'll hear now from the Commonwealth.
Thank you, Your Honors. Good morning, Chief Justice Saylor, Justices of the Supreme Court. May it please the Court, Adrienne Jaffe on behalf of the Commonwealth. I will be arguing the prior bad act issue. My colleague, Deputy District Attorney Fallon, will be arguing the alleged non-prosecution agreement. Your Honor, the prior bad
And
act.
why is that? Is it why do we need two lawyers?
Well, we filed a motion to split up the argument, and that motion was granted. So since I've been working on the prior bad act since the inception of this case, and Mr. Fallon has been working on the other issue, that's why we submitted our motion.
Thank you.
Thank you, Your Honor. The prior bad act evidence in this case, the defendant's drug-induced sexual assaults of 5 women, was relevant under 3 separate grounds. First, it was relevant under the absence of mistake exception under 404B to rebut a defense. In this case, the defense was consent. That is, it had a tendency to prove that the defendant was not mistaken about whether or not Andrea Constant was conscious enough to consent to any sexual contact. The evidence was also admissible under the common planner scheme exception. The defendant engaged in a years-long signature predatory pattern of seeking out and intentionally isolating young women so he could intoxicate them for the ultimate purpose of sexually assaulting them. So his plan was to intoxicate young women to eliminate consent. And thirdly, Your Honor, I would submit that the evidence.
Counsel, I apologize for interrupting you, but you keep saying the 5 women were sexually assaulted. It's my understanding that the last individual, the young woman that was interviewed for a part on the Cosby show, there's no allegations of sexual contact. It's that she took a medication, fell asleep, and woke up.
Yes, Your Honor.
So
And
share with me, how can you represent that there was sexual abuse on that person when the record evidence indicates just the opposite?
Your Honor, I would submit that the signature was isolating and intoxicating young women for the purpose of sexually assaulting them. And Lisa Loveland, you're correct, Your Honor. She did in fact testify that she has no recollection of being sexually assaulted. She has no recollection of what happened after the defendant gave her a drink. She drank it after the defendant asked her to sit in between his legs on the couch, which she deemed to be odd and inappropriate. And then he began stroking her hair. Then she basically passed out and was unconscious until she woke up 2 days later in her apartment. But the bottom line is that the part of the signature is the entirety of the contact and the conduct between the defendant and these victims. And
Ms. Jaffe, Tom Saylor, but that conduct you described, the steps, the young women, there's literature that says that's common to 50% of these assaults, thousands of assaults nationwide.
Your Honor, it's the mentor-mentee relationship. It's the fact that the defendant was built trust in his victims because of their mentoring relationship, because of.
I understand that, but you see, if that was the case, maybe you dispute the literature, but in the briefs, they cite treaties and literature that says that's common to 40 or 50% of these assaults nationwide, the number in the thousands.
Well, perhaps it is true that 50% of sexual assaults are drug-induced sexual assaults.
How can that be a common scheme?
According to what's in the defendant's brief, there's been no evidence at trial as to any statistics, and I would submit that's not part of the trial record, so that shouldn't be considered by this court. But Your Honor, the defendant engaged in a pattern of seeking out young women. He met them through their employment or their career. He offered to mentor most of his victims. There was a built-in level of trust because of his status in the entertainment industry and because he held himself out as a public moralist. the victims were legitimately in the defendant's presence because he invited them to the location within his control under a guise. And each incident occurred again in a location within the defendant's control. So he could intoxicate these people, carry out his plan without any interrupted discovery. And then he intoxicated them, waited until they were unconscious or otherwise unable to consent to any sexual assault, and then either sexually assaulted them, or in the case of Lisa Lott Loveland, he engaged in what I would submit as untoward sexual conduct, inviting a young woman to sit in between his legs and then starting to pet and stroke her hair.
Counsel, this is Justice Donahue. What are you describing? A signature? A signature crime? Is that what you're describing to us? Because
Your Honor, I am.
Let me just.
I apologize.
Adjusting the question. The assault that took place here, the alleged assault that took place here, took place in the defendant's home after an 18-month relationship with Miss Constant, after meeting her mother, after going on trips with her. I mean, you know, if you're talking about a signature, you better incorporate all of the facts that we have in the case that's on trial with what you are offering as a signature, because frankly, I don't see it.
Your Honor, certain differences. Well, let me say this first. Miss Constant was not the only victim that the defendant had a lengthy relationship with. He had a several years long relationship with Lisa Lott Loveland. He had a relationship with Janice Dickinson. She had been to his apartment in New York prior to the assault, and he sought to mentor her. He also had a relationship with Shalon Lasha. He had spoken to her grandmother on the phone. He had come over to Shalon Lasha's house for dinner. And he also had a relationship with Heidi Thomas. He spoke to her on the phone on numerous occasions. So it's not true that he only had a friendship or relationship with Andrea Constant. And in any event, Your Honor, the actual relationship is just one of many factors to take into consideration in making a determination as to whether or not something is a signature. There are certain distinguishing factors that are inconsequential to whether or not a crime is a signature or whether or not absence of mistake applies. That is, whether or not the defendant was mistaken in assessing Ms. Constant's ability to consent to the sexual assault. And I would submit that the absence of mistake exception, which was the main exception that we proffered this evidence for, has a lesser threshold of admissibility than does the common planner scheme. Whereas the common planner scheme, admittedly, as is pointed out in several opinions from this court, and as the defense points out in his brief, there is, in fact, some conflation between in common planner scheme, for instance, whether or not it's being admitted solely to show a common plan or whether or not it's being admitted for identity purposes.
Can I jump in, counsel? Can I jump in on that for
Sure.
a moment? You've referred to an alleged signature aspect. Identity is not an issue here. So where are you going with this signature allegation? That's number one. And number two, with respect to your repeated argument about absence of mistake, how does that factor in here when Cosby never argued that he made a mistake or that he made an accident or something like that? He argued consent. Can you answer those two questions for me?
Sure, Your Honor. In terms of consent, I would submit that absence of mistake has been admitted in numerous cases or several cases in this Commonwealth to demonstrate an absence of consent, and I would submit that was the defense here, an absence of consent. And numerous cases such as Commonwealth versus Tyson have allowed evidence to come in to show absence of mistake. And in that case, Commonwealth versus Tyson, the defendant was on trial for rape of an unconscious person, and a prior bad act of a rape of another unconscious person came in. And the Superior Court, sitting en banc, found that that was in fact admissible to establish a lack of consent. And also another case, which was not cited in my brief, Commonwealth versus Kiersgaard, that was a 1990 Superior Court case. That was a situation in which a defendant was on trial for raping a teenager, and evidence came in of a prior rape of a teenager to came in for absence of mistake to show that he was not mistaken as to whether or not the victim consented. So there are cases in this Commonwealth that allow for absence of mistake to show a lack of consent. And in any event, Your Honor, admitting other act evidence to rebut a defense is a staple in Pennsylvania jurisprudence. And the effectiveness of the rebuttal here is enhanced by a distinct pattern of similar crimes indicative of the common conscious design here. For instance, in Commonwealth versus Buskowski, that was an opinion of this court. It was a bathtub drowning case. The defendant was on trial for the murder of his wife. And incidentally, his prior wife died the same way in a bathtub drowning. And in that case, the court found that the evidence was admissible of the prior wife's drowning under the absence of mistake exception to rebut the defendant's contention that the act was the result of a deliberate act. And in Commonwealth versus Hicks, Your Honor, as well, the prior that was a homicide case, which I'm sure this court was aware of. It was just a few years ago. And in that case, one of the reasons why the prior bad act evidence came in regarding 3 prior assaults was for absence of mistake, to show that the victim in that case didn't die of simply a drug overdose, but rather it was a deliberate act of the defendant. So what we're doing here in proffering this prior bad act evidence to show an absence of mistake is nothing different that has been done in this court in numerous occasions to rebut a defense that's being proffered in this case.
But counsel, back to Justice Weck's question. The defendant here didn't claim that he made a mistake in thinking that there was consent. That's an additor by the Commonwealth in order to create a basis to assert this evidence.
Well, Your Honor, I disagree, because perhaps it's just a matter of semantics, but the defendant was claiming consent. That was the defense. So by implication, he's saying he was perhaps mistaken in assessing her ability to consent. So I would submit that they would be the same thing.
He wasn't asserting that at all. I mean, he was asserting consent. In order to proffer this evidence, the Commonwealth twisted that defense into, oh, now we're going to prove that there wasn't a mistake about the consent. They're really 2 totally different propositions.
Well, with all due respect, Your Honor, I don't see them as being different. However, also, the evidence was also admissible under absence of mistake to show that Andrea Constant was not conscious enough to consent.
Let me ask you this, counsel, before we get much deeper into this. Why did you need this evidence? You had you had the complainant who is capable of testifying.
Nixon made clear that this case, or this exact scenario, created a heightened need, noting that if the evidence in that case was excluded, the Commonwealth would have to rely solely on the uncorroborated testimony of the victim to counter the defense of consent. Now, I will say there was other corroboration of Andrea Constant's testimony, but in terms of consent, there was no other corroboration of her testimony. And in addition, Your Honor, the victim—
Ms. Jaffe, excuse me, but you really, I think, you focus on the lack of consent on the part of the victim, but you're really trying to demonstrate appellant's knowledge of that lack of consent. And that was the argument of the appellant, don't you see, when you use that doctrine, absence of mistake. You want to inject that before the jury to show that the defendant lacked knowledge of lack of the victim's consent. And I come back again to the problem with that type of testimony, legally and within the literature. That's going to require a jury inference into the appellant's mens rea, which is really what you're focused on. What was the defendant's state of mind? And I'll read you again that the trier of fact can reason from the starting point of the uncharged crime to a conclusion about the mens rea of the charged crime only through an intermediate assumption about the accused character or propensity. And that's the legal issue that confronts this court in terms of the sanctity of the verdict.
Well, Your Honor, I don't think that's an inference that needs to be taken or adopted, because the whole absence of mistake, it's coming in to show the lack of consent, and the consent.
No, it's coming in to show the mens rea of the defendant with
Your
respect to lack of consent.
I would submit that it's coming in to establish the actus reus, because part of the aggravated indecent assault, the actus reus of it is not just the digital penetration, but it's the digital penetration without the victim's consent. That's part of the actus reus. And to bring in absence of mistake, I would submit it's simply demonstrating that Ms. Constant was not consenting or could not consent because of the intoxicants that were provided to her.
Ms. Jaffe, it's Justice Todd. You referred to, when you were discussing the prior bad acts, I thought I heard you refer to them as prior crimes. Did you do so?
I don't know if I did, it was inadvertent, and I generally say prior bad acts because, and I'm well aware of the rules. It doesn't have to be a conviction in order to be a prior bad act. It can be crimes or other acts. And in this case, there are other acts. I've made no, if I did make an assertion that it was a crime, it was inadvertent, and I apologize.
That's all right.
But I will say that there doesn't need to be a conviction, prior bad acts to come in, as the title of 404B makes clear, other acts are sufficient.
I understand that, but did any of these prior victims report, prosecute, or go to court in any way over the incidents?
None of them went to court anyway. In terms of reporting, they did not report the incidents to the authorities for many years afterwards. However, many of them did in fact report them to some people. For instance, Chilan Lasha, she was the 17-year-old that the defendant intoxicated and sexually assaulted in a hotel room. Immediately afterwards, she drove to her guidance counselor and told her guidance counselor what happened. Janet Dickinson, she confronted the defendant the next day, actually, and basically said, "What the heck did you do to me?" And then after that, she in addition, she told like her publicist, she was an actress, she told other people, including Dr. Drew Pinsky, when she was on Celebrity Rehab show with him. This was a couple years after the incident, well before the Andrea Constant incident. So she told him, she told her publisher when she wrote a memoir, and in fact, she wanted to include it in her book. However, after speaking with the legal team, they said, no, we can't put this, that he raped you and intoxicated you. And that was years and years before the assault came out. Several of the other prior bad act witnesses, when they went home, they told their roommate, another one told their sister. But in terms of reporting it to the authorities, no. And as Dr. Ziv testified, she was our the sexual assault victim behavior expert. A lot of times these people don't report right away. And she explained all these rape myths that the defendant sought to debunk in its cross-examination of Andrea Constant. So she explained why they don't report these things to the authorities. Who's going to believe me? I'm saying Bill Cosby sexually assaulted me after intoxicating me. So that's why they didn't go to the authorities.
Counsel, share with me your position of the use of prior bad acts dating back as far as 37 years ago to 1984 with Heidi Thomas, and how that is probative of current.
Okay. First of all, Your Honor, I do want to clarify something. I know you're saying 37 years back, but the time is from the time of the incident to the time of the Andrea Constant assault, not the time of trial. So they were actually, the first assault that we introduced was in 1982. The assault on Andrea Constant was in 2004. So it was 14 to 21 years. And that's just, I know the defendant says 15 to 22 years in its brief, but the assault on Andrea Constant occurred in January of 2004, so you don't count January. So I will answer your question, but in terms of 14 to 24 years. First, I want to point out that there is no bright line for what constitutes remoteness. The determination should be made on a case-by-case basis based on the unique facts and circumstances of each case. There has never been a case that unequivocally says 10 years is too long, 20 years is too long, because you have to consider the facts of each case. And focusing solely on the time lapse is improper because remoteness is only a single factor the court is to consider. And importantly, the remoteness or the time period is inversely proportional to the number of similarities between the incidents. And here there are abundant similarities, as I detailed, and I will be happy to detail them again, but they are set forth in my brief. And I also want to point out that numerous cases have allowed in prior bad acts for the time frame around the same time of this case. For instance, in Commonwealth versus Lucktish, that was a Superior Court case, the court allowed in 19-year-old sex assaults, and they were sex assaults going from 19 to 14 years before the current assault. And in that case, the court also let in another sexual assault, eight years before that. And Commonwealth.
Counsel, I apologize. I understand the case. So I understand. I guess the question or concern that I have in Pennsylvania jurisprudence, what you're advocating is that 3 decades of an alleged prior bad act is admissible in a trial because there's no ceiling as to the staleness or remoteness. Yet we have to balance that against our own rule of 609 of evidence, in which the use of a conviction is considered stale in the impeachment of a witness, unless there's the other argument, unless it's more probative. So how is it that we are to digest the use of an alleged act is admissible 14 to 37 years later, yet we don't look as a trial lawyer and as a trial judge? I'm sure you, as a trial lawyer, have been exposed that when you try to introduce a stale conviction, it's objected to and usually sustained. How is it that what you're really asking us to do is to place an alleged prior bad act in being a superior position in its introduction into a trial as opposed to a conviction? I'm really struggling with that position.
Okay, and I'd be happy to answer that, but I first want to say I would disagree that it's routinely not allowed in if it's over 10 years old in a case of point was in this case, one of our prior bad act victims had a prior conviction that was over 10 years, and that was allowed in by the trial court. But in any event, the distinction I would say in this case is, in your example, we're talking about a single conviction. Here we have a recurring sequence of events, and that's why it's important when you're considering remoteness. So we had the time frames of all those witnesses that closed up some of the gaps to more sufficiently demonstrate this recurring pattern or this recurring sequence of events of the defendant isolating, intoxicating, and then sexually assaulting young women.
Counsel, that segues me into one additional question.
Sure.
Let's talk about that. My understanding of the facts of this case was that the judge, Judge O'Neill, permitted the Commonwealth, out of those 19 witnesses, to choose any 5 and then introduce them, correct?
No, that's not correct, Your Honor. The court allowed the Commonwealth to choose 5 out of 8. So we had
Okay.
1 to 19 listed in chronological order, 19 the closest to Andrea Constand's assault. He said we could choose any 5 from number 12 through 19.
Counsel,
While he said that, he also stated that he believed the evidence was all relevant. All 19 of them were relevant, but in only letting us bring in 5, he was weighing the probative value of this evidence against any potential for unfair prejudice.
Counsel, Justice Baer, and again, I'm just trying to follow up. Most of the argument today has been whether or not this evidence falls under 404B and is admissible at all. But I think I started this argument an hour ago by asking your worthy opponent about abuse of discretion. And I'm still there to some extent. Did you advocated putting all 19 in? Is that correct? Oh, I lost you.
I'm sorry, can you hear me?
I can't hear you now. You advocated putting all 19 in.
We did.
All right. 150? Is there any point at which we're not trying whether or not the defendant assaulted the victim, but rather trying whether the defendant assaulted one of the other 19 or 18 or 5? And again, I recognize abuse of discretion is a broad standard, but you can still get to the point with evidence that's terribly probative that it's just too much and that this defendant did not have a fair trial.
Well, Your Honor, again, like the
Arguendo, it's admissible, but the amount of it is such that the weight was conflated the issue from whether this defendant did this crime to whether he did the other 5 or 18 or 19.
Well, Your Honor, in addition to the judge only allowing us to present 5, the court kind of acted as a gatekeeper during trial. After the first prior bad act witness, the Commonwealth, or excuse me, the defense moved to preclude that, to strike that testimony, and then she moved to preclude the next testimony. So the court was essentially revisiting the ruling, and he said on the record, you're allowed to have up to 5. So he made the determination what would have been unfairly prejudicial or what was too cumulative, and that's what the job of the trial court, to exercise his discretion and do that. And importantly, there's no bright line rule that 4 prior bad acts or too much, or 5 or 6. It depends on the facts and circumstances of each case. And there have been several cases in this Commonwealth that have allowed in more prior bad acts. For instance, in Commonwealth versus Frank, a Superior Court case, which I cited in my brief, a therapist was on trial for assaulting a young boy, sexually assaulting a young boy, and the court allowed in 6 prior bad acts to establish a common plan or scheme. And then in Commonwealth versus Arrington, which was a case from this court from a few years ago, Justice Baer, I know you wrote the opinion, and Justice Todd, you joined in the majority opinion. In that case, that was a homicide case, and the court allowed in prior bad acts from 2 previous girlfriends and then some prior bad acts from a man. But each of those girlfriends testified as to multiple instances of abuse, and the man testified as to several instances of abuse. So I believe about 12 instances of abuse came in. So although in that case there were only 3 witnesses taking the stand, there was about a dozen separate instances that were described. And the same with Commonwealth versus Lucktish and O'Brien, what I cite in my brief, sex assault cases. In them, only, I think, 2 prior sex assault victims came in. However, they testified as to numerous assaults that were committed on them by the defendant. Here, we only had 5 prior bad act victims. And while the defense says the prior bad act victims took up half of the testimony, That is not true. There were 25 witnesses that testified at trial over the course of 10 days. We had 5 prior bad act witnesses. That's it, aside from 2 corroborative witnesses that took the stand for about 3 minutes each. That was 2 days of a 10-day trial.
Ms. Jaffe, we're going to hear now from your colleague, Mr. Fallon, because we want to conclude this argument, which is gone on for a while.
Your Honor, if I might just take 2 minutes to address harmless error very quick, because I know that was brought up.
Yeah.
If I may, it's our position, Your Honor, that even if for some reason this court finds that the evidence, the prior bad act evidence was not admissible, I would submit that any error was harmless in light of the overwhelming evidence. We had Andrea Constand's testimony that the defendant provided her intoxicants, that those pills rendered her incapable of consenting, that she was incapacitated, that the defendant penetrated her vagina with his fingers. He put her hand on his penis and masturbated himself, and he fondled her breasts.
If that's true, why'd you need the 5 witnesses?
Well, Your Honor, there's a difference. This was our pretrial assessment of the case. We did not know at the time exactly how our evidence was going to go in. And while we said we needed this evidence, in saying that, the evidence was very important to us because the victim didn't promptly report, because we knew from everything that the defense did first time around and leading up to the trial that they were going to relentlessly and ruthlessly attack her credibility. And in fact, they did. And we also knew that they were going to call Margot Jackson, who was their super witness.
That has nothing to do with harmless error. So we're going to hear from Mr. Fallon.
Okay, thank you, Your Honor.
Good morning, Your Honors. Thank you for allowing us to split time. May it please the court, my name is Bob Fallon from the Montgomery County DA's office. I'll be addressing defendant's non-prosecution claim. He alleges that Bruce Castor in 2005 promised him transactional immunity and that he relied on that when deciding to sit and answer questions at a civil deposition. The trial court, however, after 2 hearings and hearing from the witnesses, found that there was no promise and that there was therefore nothing for defendant to rely upon when sitting for those depositions. Those findings and credibility determinations are supported by the record. That leaves this court, I'd submit, with no mixed questions of law or questions of law to answer. It is simply, the court does not have to reach the issues of promissory estoppel or any of the other legal or mixed questions that the defendant raises.
Counsel, could I ask you, counsel, pardon me, on that, assuming for the sake of argument that you're right about there being no binding agreement, there would, under any circumstance, not be any argument about the prosecutorial exercise of discretion here. That is to say, as memorialized in Mr. Castor's press release, that a decision was made by the DA's office not to prosecute this defendant. Since we're the Supreme Court, this case obviously has implications well beyond this defendant. What is the lesson that emerges from your position in this case regarding the reliability of prosecutorial decisions? What is the implication for the thousands of promises made by prosecutors across the Commonwealth every day or every week? Plea deals, immunity agreements, non-pros agreements, agreements to cooperate with witnesses, et cetera, in return for something, et cetera. If your office's word is not its bond, and we validate your position here, what is the lesson that emerges from beyond this case for all cases going forward in Pennsylvania? Do you understand my question?
I do, Your Honor. And the fact is, prosecutors are bound by contracts that they enter into, or if they do make a statement that a defendant reasonably relies upon, then the defendant can seek some relief. The question here, it doesn't really reach that issue because the only thing the defendant can point to is a press release that says that the prosecutor is not going to press charges. That same press release leaves open the possibility that the case will be reconsidered. In the press release, District Attorney Castor says, cautions all parties to this matter that he will reconsider this decision should the need arise. Not only that, but in 2015, he was interviewed by the Inquirer, and he told the Inquirer, I put in there, referring to the press release, that if any evidence surfaced that was admissible, then I would revisit the issue. And that is evidently what the DA is doing. So I think the lesson that this case would teach is that simply because a prosecutor announces he or she is not going to press charges in a case, without more, that does not give the defendant license to say, wow, that's transactional immunity. It's really prosecutor 101 that you do not close off cases, even if they go cold. You leave open the possibility that if new evidence is discovered, that you can then go back and live to fight another day in court. There is no reason for a prosecutor to just say, okay, I'm not going to press charges. Defendant's free and clear forever, no matter what turns up in the future. And no matter if a federal judge, as in this case, released a civil deposition and in an opinion said, this deposition reveals behavior that is perhaps criminal. Prosecutors should not and do not do that. They sometimes don't press charges in a case, but they never, in my experience, will just, for the sake of the civil case, say, we are never going to do that. And it's especially strange in this case because Castor ended this investigation while the investigation team was still strategizing on the next steps. And that's from Detective Richard Schaefer's testimony at trial. He said when he got the call that the case was closed, he and his team were still mapping out the next steps in the investigation. So
That's a call. That's a call. Just one brief follow-up. Can I just have one brief follow-up on my question? A sitting DA made a decision memorialized in a press release. You don't like that, you being the successor's office, that is. But why does that not bind you as the successor office?
Your Honor, I think because by its own terms, it's leaving open the possibility that it can be reconsidered. I mean, it's right in the press release, and there can be certainly, the court was talking about reasonable reliance if we get to that analysis. If we're just talking about strictly the press release, nobody should reasonably rely upon that for transactional immunity. That would be a horrible precedent to set. To say that when the actual document says the prosecutor may reconsider it, that defendant can take that press release and say, I am forever immune. And then a court is later going to enforce that. That is not fair. That is not fair to the Commonwealth, and it's unreasonable for defendants to expect that. If they are, yes.
All right, it's Justice Todd. Isn't it fair also to look at Mr. Cosby's reasonable reliance on the agreement he believed he had, based upon the fact that he went forward with the civil deposition and put himself out there for those questions and did not raise any objection at that time or invoke his right to remain silent? Isn't that indicia of reliance on what he believed to be an agreement?
Well, Your Honor, it is not. And I'd also just point out that the trial court did not believe that it was indicia of reliance. And that's really the key issue here, whether the trial court had support in the record for its findings. And I'll explain why it's not indicia of reliance on this so-called promise from Castor. Defendant sat for a police interview with multiple detectives during the investigation, and he gave an exculpatory account of his interactions with Andrea Constant. He did not invoke his Fifth Amendment rights, and his lawyer, Schmidt, who the court deemed rejected his testimony, but Schmidt said that he had interviewed defendant before the detective interview, and he felt confident that the defendant would not incriminate himself. That's why Schmidt let him sit for the interview, because it served his client's interests. The defendant was able to get through that interview and end up giving an exculpatory account. Not only that, but he then, with Schmidt negotiating the deal in detail, in writing, in multiple stages and exchanging of papers with the National Enquirer lawyers, negotiated for the defendant to sit down with the National Enquirer after the investigation and talk about Andrea and the whole incident. Again, he did not invoke his Fifth Amendment rights. The defense team, which was consisted of John Schmidt, Patrick O'Connor, and Walter Phillips. I mean, as we talk about an excellent defense team, they let him sit because it served their best interests. And so if he had invoked his Fifth Amendment rights at the civil deposition, he would have faced negative consequences. And in fact, the victim's civil attorneys, Troiani and Kivitz, they both testified, we wanted him to invoke. It would have been better for our case because, one, the jury would have only have heard from Andrea, and two, we would have had a favorable instruction that would have allowed the jury to infer that because the defendant invoked his Fifth Amendment rights, his testimony would be unfavorable. So defendant sat for the civil depositions, tried to give an exculpatory account and essentially did, although he slipped up and made statements that came back to haunt him, but he was trying to do exactly what he had done before. He sat for the interview with detectives, with the National Enquirer. He thought he could get away with it. His defense team thought he could get away with it. He was trying to avoid negative consequences of invoking the Fifth in this situation, and it backfired on him. That's what happened. There was no, and one important point, and I think Justice Doherty mentioned it earlier. The defendant, by his own allegations, believed he had transactional immunity from Castor for Andrea Constant. That's it. No other victims. Yet at the deposition, he would not answer a lot of questions about Andrea. That's not consistent with someone unburdened by transactional immunity. He was compelled to do so by the federal judge. And yet, and importantly, and this has never gone rebutted by the defense or even explained, is that defendant openly answered questions about other victims in other jurisdictions. Those victims would not have had he would have not had any immunity for those victims. Castor could not grant immunity for victims in California or New York or Las Vegas. So why explain that conduct? It's inexplainable if he sat because he had thought he had transactional immunity for Andrea Constant. So I don't think there was any actual reliance here. And that is in fact what the trial court found. And I want to be considerate of this court's time, but just in closing, I'd ask the court to, this court has established the deferential standard of review for credibility determinations and fact findings for a reason. The cold record does not capture everything that transpires in a courtroom, from the mannerisms, tone of voice, gestures, expressions, the change in demeanor as a cross-examination.
All right, guys, I'm back.
All
Live
these things
stream
aren't
with
captured in the
Nicole.
cold record. And as someone who was there,
Y'all
that
just
day,
stay tuned, but they're going to recess right now. I don't know if you guys can hear me. Hold on a second.
Does not capture everything that happened. But even despite that, if you read this record, there's ample support for the trial court's fact findings.
I'm doing a live stream with Nicole, so you guys, that's the end of the live stream, but y'all tune into Nicole's view. I'm going to do some commentary.
He properly resolved and denied this claim.
Thank you, Mr. Fallon. Unless there are any other questions, we'll conclude this argument.
Thank you, Your Honors.
Thank you, Your Honors.
Take a 5-minute recess. And
oh, wait, hold on one
next
second,
case.
Nicole. I got to get my personality lined up. Hold on. Okay. Hold on a second. I was trying to, I don't know why my green screen went off. All right. Oh, damn it. Okay, because I'm actually live streaming with you, and I'm live streaming on my other channel because I wanted to play it on there as well, and give my commentary. Can y'all hear me? Okay. All right. So what you essentially saw, Nicole and guys, my commentary, I liked how it went. Especially you saw how they were grilling the prosecutor. I can't think of her name. Was it regarding our bad act witnesses about the mens rea? And what got me was at the very end when the chief justice his name isn't Dorothy. I don't think it was Dorothy, but the Chief Justice Saylor. He asks her about it. Why would you put 19 women? And she says, well, you know, we knew they were going to attack her credibility, and he drugged this woman. He made her masturbate, and he forcibly masturbated to her while grabbing her breast. He says, well, if all you needed was the complaint, why did you add the other prior bad act accusers? Why do you need all 5 of them then if you had the complainant? You know, and that one caught me. I started laughing. I wasn't a fan of the, you know, and even when you saw Dorothy, because he asked her, Bogine, about Bill Cosby, isn't he knowledgeable about the about self-incrimination and you know, and the Fifth Amendment? Well, Bill Cosby is not a lawyer. He's not an attorney. He doesn't have legalese like I do or any other else. He's relying on the guidance of counsel. So when he makes those comments and he, you know, gave that testimony, he was under the impression that he had a Fifth Amendment right against self-incrimination because the prosecutor said in the press release there would be no charges. What they also failed to mention was that there was an email Castor and Schmidt, Bill Cosby's lawyers at that time, where he said there would be no prosecution. So that is in writing. What they're talking about promissory estoppel in regards to, he relied on that to, in Louisiana, we call it detrimental reliance as well in contract law. Contracts do not have to be in writing to be effective. You know, like I've told you guys before, if you make an offer to someone and they accept and they do conditions on that, then you can be legally bound by the court if it goes to court that, hey, this person did all of the necessary steps that you requested. You promised him to give him such and such in exchange for that, those actions. You know, as long as it wasn't against public morals or against the law, then it was effectively binding. So, but I wasn't a fan of the last argument with that last prosecutor in regards to the promise by the DA. I think he has a great chance with regards to the prior bad act, because you even saw the female justice that said she couldn't see it. Like, she couldn't see how you could make that connection with regards to the mens rea. Mens rea meaning your mental state of the defendant, and actus rea is the actual act. Bottom line is, you know, I think, you know, for them to even hear the argument to beginning, to grant the appeal, meaning to grant the hearing, was an indication that he was going to be vindicated. I'm not there yet, but I like the way it went so far. Right. Right. Well, you can't be emotional with it. It's business, so you can't get caught up in your emotions. You gotta nail the facts with it, and they took the most pressing issues, the most poignant points, which is the prior bad acts and the prosecutorial agreement. Keep in mind also, some other issues could not be raised because it got waived in the the lower courts. Remember the audio recording that they found out was edited. Well, they could not obviously make that argument in the appeals and say Brady violation because in the first trial, they allowed that to go in without objection. So, and that was something that really should have happened. And I even had conversations with, as you know, seeing Nicole, I've had Scott on the show. He said that silly me, we didn't do our job with that. Same thing, so all of this stuff though, the prior bad act witnesses, I think they were, especially the judge, you could see who was on the side of Cosby. I think the female judge and Barr were agreeing with it, as well as the Chief Justice and even Doherty, because at first it looked bad when he interrupted Bojan, but then you saw he kept interrupting this prosecutor. So they took issue with some stuff that they had. County. Right. Right. Amen. Ron took it to church. I said, Brother Ron took it to church. Well, there's a whole Masa. I think it's another case, Nicole. I think they moved on. Let me see. I think they moved on to another case. Right. They grant a new trial. Well, let me say this too, and good morning to you, Counselor Frank, as well. What Frank is talking about is basically they don't have to acquit him in saying throwing out the conviction, but they could still throw out the conviction and say remanded to the trial court, meaning that they can bring in the prosecutors can retry this case again. We have a situation here in Louisiana, in New Orleans. You guys probably heard of the Cardell Hayes Will Smith shooting that made national news. Cardell Hayes is going to be granted a new trial. Basically, his conviction of manslaughter, I believe he got 40 years, is being overturned because Louisiana finally added unanimous juries and he was convicted on a 10-2 vote. So as a result of that, the new law that is in place, his conviction is going to be overturned. And he will be likely, because it's a high profile case, whoever the new prosecutor is going to be, whether it's Jason Williams or Kiva Landrum here in New Orleans, they're going to decide whether or not to bring that to trial. But he could be released on his own recognizance until then because there's no conviction. I don't know if this Montgomery County would likely try this case again because of the amount of monies that it took to prosecute Bill Cosby in the first place. You know, they asked Cosby to pay for the court fees and costs for this thing. And I don't know if Andrea Constant wants to even come back. Even Scott mentioned that when I spoke to him on the phone a while back, saying that if this went to trial again, meaning it ended in a mistrial, there was a likelihood she was not going to come back and testify. Either way, if they do get a new trial, I'm praying that a new judge gets appointed on this case, because O'Neill does not need to be on that. They need to put it in a new section. He is, and I stand by it. Normally, you can't accuse a judge. You have to be respectful to attorneys and lawyers. But, the bottom line is the facts were the facts. He was clearly biased by this. Tom, even stated that publicly, saying that this was the most biased trial I had ever been a part of. And he's tried cases in death penalty cases in the Deep South that were much more impartial. Yes. Yeah. Yeah, that was something that they brought up too. The other thing too, when they mentioned Shalane Lasha, one of the things they should have mentioned is the fact that this woman was a fugitive from justice that was allowed to even testify. Her testimony should not have even been admitted to begin with. I mean, and she didn't even claim rape. She claimed that he humped her toe, or humped her leg, like a dog. Well, he is a cute dog, I guess, but I mean, damn, they don't get that serious. Right. Nicole, apparently I pissed off some Q dogs that are in the chat. Brian Brown and Squeaky G. Shit. I don't care. I know a lot of Q dogs. I know a lot of Q dogs. Yeah. Joe Torre. Yeah, Steve Harvey. Yeah, well, all right. All right, thank you, brother. All right, thank you for having me on, and shout out to the chat and the Qs. Brian said we don't claim Steve Harvey. What your ass say? Uh, yeah, yeah. I makes a lot of money to be a Q dog. Thank you, player. I gotta throw in some comedy with that. No, I thought it was great. I thought that Miss Bogine did a great job. Uh, all we got to do is pray and keep Mr. Cosby in prayer. And this is important because it sets an implication for future cases to come. And even one of the justices said that because If indeed somebody can be prosecuted off things they say in a civil deposition after a DA says that there would be no charges, then we don't need the Fifth Amendment anymore. If that's the case, then there's no right to against self-incrimination or double jeopardy. Hell, what about the Sixth Amendment, right to a fair and speedy trial? Because that was also something that was denied to Mr. Cosby. If you're trying to bring charges against him, you know, you waited 12, 13 years to bring this decision when, in fact, you had the information if you wanted to go after it then. They chose not to. So I certainly think that he has a great chance. I like what they said with regards to the commentary by Ms. Bogine and even the judges. We just got to keep our fingers crossed. And Nicole, I appreciate you having me on as always. And I know you're going to have Andrew Wyatt come on a little later, so I'll be tuning in.
To try to supply and feed our people with the right information to make the right decisions on things. And it's not over. You know, we're still fighting the war. We can win a couple of battles, but we still got to fight the war. But I want to leave people encouraged because George Washington, you know, the so-called founding father, he lost more battles than he won, and yet he still won the war.
All right, guys, do me a favor. Put your YouTube channels in the name part. Let me lower this banner because there are people asking, what's his channel? What's that channel? So just put it as your name. And guys, I want you to subscribe to all of their channels. Great stuff. I'll give you guys a moment. I don't know if you're able to edit it. I should have just did that, but I was last night, I do my Zumba and I was just like out of it.
You do a lot of work. It's on song.
Yeah. So y'all make sure to subscribe. And also, please come back because I'm going to have Mr. Cosby spokesperson, Andrew Wyatt, join me 1 p.m. Central Standard Time, 2 p.m. Eastern. I guess that's 12 if you're on the West Coast. No, 11 if you're on the West Coast. So yes, make sure to subscribe to Drew Story News, Gavin Richard Presents, and We All Be TV. And I got to come on your channel. I've never been on your channel, Drew. I've been on Gavin's, and yeah, I haven't been on Drew's, and We All Be TV. But make sure to subscribe to all their channels. Okay, great.
That's the YouTube channel there, Gboot2786.
Yes, I'm giving folks a chance. I thank all of you, and I thank all of you who stopped by, who shared, who liked this broadcast, who donated. I thank you guys so much because I cannot do this without you, without the support of the people. I genuinely thank you. This is very important, not just because it's Bill Cosby, it's because it's us. This is us. Doesn't matter what your title is. You guys saw what can happen in an instant. And we have to be together. We have to research stuff and not be so easily misled by propaganda, lies, mainstream media, whatever. I don't know who else was carrying this today. Probably Court TV. You know, I'm sure CNN maybe, you know, dropped in. But I wanted you guys to be on here because we need our own media where we're telling the truth. So yeah, that's pretty much it. I'm going to let you guys go. I'm sure you have other things to do. I know some of you have work and all that good stuff, but yeah, just come back if you can. 1 p.m. Central Standard Time, 2 Eastern. Thank you guys so much.
Norm King says, I'm about to
Love
get a
you,
bunch of
madly.
hate mail from the Q dogs. Yeah, bring it on, player. I could shuck corn in 1 second with these teeth. Yeah.
Yeah,
I love the Q dogs. I got Q dogs that are friends. Don't worry. I ain't worried about that. I stay strapped too. But no, thank you, Nicole. Thank you to the chat. Y'all were great, man. And
excellent.
Yeah, and I have Ron on. I told you Ron is basically a walking history vault.
But still research me. You can't trust a black man. When you can trust the white folks, you can trust Anderson Cooper. You can't trust me though.
Yeah.
Do your research.
Your research. That's all I have. Your
You a winner. You was a winner, player with a WH.
All right, guys. Well, you guys take it easy. Take care. And I'll see you guys soon. All right.
Mr. Trump wanted to know about my line of suits. Yeah.
Bye, guys. Bye, Gavin.
B1.
B1.
See you later, Drew. See you later on.
See you. Blessings. Love y'all madly.
Bye-bye.
Bye, Nicole. All right, guys. Yeah, I don't know if you guys could hear the sound or so forth. I was doing that live stream. I probably pissed off a few Q dogs. That's okay. I got more friends. No, but I got a lot of Q dog friends. I wasn't a jab at them, but I was just, I was just saying. You know, you saying Bill Cosby humped your leg. Well, I guess you can make a point he's a Q dog, but you're like a dog. But that's no disrespect to them. I don't believe that BS though. But y'all see, that's just jokes. All jokes aside, you all saw what was going on and what transpired in that case. And I broadcasted that live stream of the court hearing because some of you probably did not know the things that were going on. And you saw the relevant facts that were being talked about in the broadcast, that the Supreme Court justices of Pennsylvania were brought up. Most people didn't know about the 5 prior bad act witnesses because the mainstream media didn't want to tell you everything that was going on. Like when you heard the story of the woman, Lisa Loveling, who was actually sitting and went to Bill Cosby's house, and she didn't even I don't even think she even took a Quaalude. She actually, from my understanding, I think she was high before she even came in there. But you saw how they didn't even say that he engaged in any sexual contact. She just said she went there, fell asleep, and then walked out, which even in and of itself doesn't make sense to what they're saying, that, well, no rape took place, no touching, she just woke up. And she went there with a friend. Janice Dickerson, of course, she even admitted on the stand that she used the words that Tom described was artistic privilege with regards to her allegations with Bill Cosby. You see, that stuff is a part of that as well. But you guys didn't hear all of that. You guys were not meant to hear all of that because mainstream media ignored it. So that is why you must continue to support channels like myself, Gbu2786, channels like Brother Ron Hurd of We All Be News, Nicole's View, and Drew Story News. Support new Black media, donate to the Cash App if you can. You see the live ticker at the bottom. So I got to get out of here, guys, but y'all tune in because Nicole is going to be doing a live stream with Andrew Wyatt later today at about 12 o'clock Central Standard Time, if I'm not mistaken. Y'all tune in to her channel. I was blessed to be a part of the panel. She really has helped me grow with my subscribers, and she's a beautiful Black woman, and I think that comes from the fact that she has a son and a husband that she loves. And she does not want them to live in a world where they are judged just for simply being a man and being Black in America, being a Black man. So I'm out of here, guys. Y'all be safe, be blessed. I'll holla. Peace.